As Chief Counsel and General Manager of the California Statewide Law Enforcement Association, Kasey Clark receives numerous questions from CSLEA members, including what happens when you are no longer medically capable of physically doing your job? How does an employee retire for disability?
The process requires an application filed by somebody that indicates that there is sufficient information to demonstrate the employee is no longer capable of doing their job. So an application has to be either filed by the employee or the employer.
Is there a minimum time that someone has to be employed in order to be eligible for disability retirement?
Yes, there are two basic types of disability retirement options. One is work-related, also referred to as service-connected disability retirement or industrial disability retirement. The other is a non-work-related or non-industrial disability retirement. For a work-related disability retirement, there is no minimum service required. So we have people that are employees. They could be, as long as they're an employee, who may be cadets in an academy, could be first day of the academy and doing some physical fitness testing. They blow out a knee and are no longer capable of doing the job. They're eligible for disability retirement benefits. For the non-work-related benefits, you have to have a minimum of 5 years of service in order to be eligible for those benefits.
Are both peace officers and non-peace officers eligible for the benefit?
Yes, and I know a lot of the non-sworn employees, particularly I got a question from a member just recently about not paying into Social Security and not being eligible for Social Security, and when they had the enhanced benefit, when they moved from miscellaneous to safety and got a higher pension benefit, that was supposedly the trade-off. Since now we've had some legislative changes that have modified those benefits back down, the question becomes, am I really getting an enhanced benefit as a safety employee? But one of the big factors that is often not considered is that safety employees are eligible for industrial disability retirement. Miscellaneous employees are not. And so that is a huge benefit. So if you have, regardless of what job you may do, you can have a dispatcher that has repetitive motion injuries that can no longer do the job of a dispatcher. There's a variety of non-sworn positions that you could have a work-related injury that would entitle you to disability benefits.
So what must be demonstrated in order to qualify for those benefits?
Well, the legal standard is, according to the case law, whether the employee is substantially incapacitated for the performance of their usual and customary job duties. That means the duties that the employee does essentially. For peace officers, that may mean duties that aren't performed that frequently, but they have to be done because they are so significant. For example, life-saving efforts, the ability to arrest and control and detain, use a firearm. These kinds of things aren't necessarily done frequently, but they are essential because they have to be done when it comes time to need to do them.
So an employee has to apply for this. Can the employer apply for it for the employee?
Yes, and I touched on that as what initiates the process as an application with CalPERS, which all of our bargaining unit members are members of the CalPERS retirement system. But applications can be initiated by the employee. The employee can file them. The employer can also file if they believe that the employee is no longer medically capable of doing their job.
Is there a benefit to have the employer file the application?
Yeah, there is a benefit. What typically precipitates the filing of a disability retirement application is generally a long period of an inability to work. Whether it's the employee's off on workers' compensation or they're off on a non-work-related injury for a period of time where they're attempting to treat, they're working with their primary treating physician, they may be recovering from surgeries, and they're in a process where they're trying to assess, am I going to be able to go back to my job? At some point in that process, it becomes somewhat evident, may not be clear, that there are issues in terms of the employee's ability to return to work. And at that point, an application for CalPERS is made. The problem is that because of the extended period of absence, the employee may not have much leave left to utilize to carry them through the application process with CalPERS, which can take several months for them to rule on whether the employee is or is not disabled. If the employee files the application, they have to continue finding a way to fund their continuing period of absence. If the employer files, the advantage to the employee is the employer has to put the employee on disability retirement advances. The employer has to estimate what the employee's pension would be if they are in fact retired, and then they have to begin paying the employee that amount of the pension pending the application process. So employers are oftentimes hesitant to get into making those advances. They'd rather the employee fund the period of the application process, but if it is possible to get the employer to make the application, it does put the employee in generally a better financial position while they're waiting for CalPERS decision.
Less out-of-pocket expenses.
Correct.
Okay, and then who makes the determination of whether the employee is disabled?
That is exclusively up to CalPERS as far as state agencies are concerned. At the local level, for peace officer employees, the local agency actually makes the determination, which can sometimes benefit and sometimes disadvantage employees because you can have political factors take part in the determination process. But at the state level, it's all CalPERS. CalPERS takes a look at the medical information that is submitted in support of the application. They have the employee sign a release so that they get access to all the employee's medical records, in addition to the ones the employee may have submitted in support of the application. They have a right to have the employee seen by their own independent medical examiner if there's any sort of conflict in the medical records as to whether the employee is disabled. And that decision is, ultimately PERS.
If an employee is then granted disability pension, what can he or she expect to receive?
It again depends on whether it's a work-related or non-work-related disability. For a work-related disability, the employee is entitled to 50% of their final compensation and the additional benefit of it being tax-free. So it can end up being close to what the employee's take-home pay is, including taxes, when they're getting 50% tax-free income based on their single highest year, which may not be their last year of employment, but whatever their highest 12 months is, the 50% is applied towards that. For the non-work-related disability benefits, a factor of 1.8 is utilized against all of the employee's years of service. And as I said earlier, the employee has to have at least 5 years in to be eligible for that benefit. But however many years is, 1.8 is utilized as a factor. So if it was 10 years in, it would be 18% of the employee's final compensation. So for non-work-related injuries, it really depends on how much time the employee has been able to get under their belt before they are no longer capable of working.
So then who decides whether that is work-related or non-work-related as far as the injury?
Yeah, initially the determination is made by CalPERS. CalPERS will take a look at the medical and generally the employee is going to, when they submit their application, is going to know, or what the employee believes is whether they're disabled based on a work-related injury or not. So the application is going to get submitted by the employee or the employer for a specific type of retirement: industrial disability, non-industrial disability. For the industrial disability applications, PERS is going to take a look and decide not only does the medical demonstrate that the employee is no longer capable of performing the essential functions of their job, but does the medical demonstrate that it was work that was a significant cause? Did the employment contribute substantially to the disability is the standard. And if PERS makes that determination, then the employee is entitled to the industrial disability pension that I've previously described. PERS could make a decision that the employee is disabled, but the medical did not demonstrate that the employee's disability was caused by work. In that case, the employee has a right to pursue a petition before the Workers' Compensation Appeals Board to get the disability converted from a non-work-related to a work-related disability, and that is done via a petition for finding of fact pursuant to Government Code Section 21166. And it's a fairly simple process, so anybody out there who's got a non-industrial disability award that has any competent medical evidence to support a work-related finding, they should contact an attorney that specializes in workers' compensation and pursue that petition, because obviously, as I've said, the differences in the amount of the benefit are significant, and most often the Workers' Compensation Appeals Board will grant those petitions as long as there's any supporting medical. And what oftentimes happens is there is no opposing evidence because CalPERS doesn't show up to contest them, and most of the agencies that I've been familiar with over the years don't oppose those petitions either. So it's something to be aware of.
So what happens then if an employee is off the job because of an injury, but then CalPERS denies the application? What happens then?
Okay, so, and this is common. There's often times where an employee believes that they're disabled, incapable of doing the essential functions of their job. The employee's treating physician believes that they're disabled, incapable of performing the essential functions of their job. But CalPERS rules, based on the evidence that they've been able to gather, based on their opinion of their independent medical examiner, that the employee's not. They didn't meet the legal standard in CalPERS' eyes. There is the option to appeal that decision and go through a full evidentiary administrative hearing if the employee believes CalPERS got it wrong in their review process. And you can have an administrative law judge make a determination on whether that initial call was correct or not. And you could even go all the way to the Superior Court and the appellate courts if you want to pursue an initial denial by CalPERS. But if the employee is going to accept that denial, then the employee has the absolute right, provided they haven't resigned, to reinstate to their former position. And that's a word of caution that I would make to any of the viewers out there is, unless you're absolutely certain that you do not intend on returning to your job, no matter what CalPERS' decision is, do not resign. Because if you resign, you've forfeited that reinstatement right, which is mandatory if CalPERS denies the application. And so the employee has a right to present themselves for return to work, and the employer has a mandatory duty to reinstate them unless the employer appeals CalPERS' decision. But that's what would happen if the employee is denied based on their application.
And how about a situation where an employee's doctor doesn't think that employee is capable to return to work? Does that employee have a right to go back to work?
Even if the employee and their treating doctor both believe that the employee shouldn't be doing the job, feel the employee is not capable of performing the essential functions, CalPERS determination trumps. So, what some unfamiliar risk management folk, analysts out there will do is CalPERS denies a disability retirement application, employee requests reinstatement. The risk management person will say, well, until we have a release or clearance from your primary treating physician, we can't reinstate you. They can't condition reinstatement on that. In fact, the Phillips versus County of Fresno case that addresses this kind of scenario, Phillips was a deputy sheriff with the County of Fresno, and his attorney wrote the county to present his client for reinstatement and said, for the record, neither my client nor his treating physician believe that he is capable of doing the essential functions of the job, but he has no choice given then the County Board of Retirement's decision that his client was not disabled to return to work because he couldn't afford to not have the pension and not have his salary. So the employer can't condition reinstatement based on medical clearance from the employee's treating physician.
Sounds like almost like a catch-22 that you get caught in.
It is, and that's why the appellate courts have come down universally on this, and that you can't leave an employee out there in limbo with no pension, no salary.
All right. And what can an employee do if their application has been denied, yet their employer refuses to return them to work?
Yes, there's a couple avenues, and fortunately at the State Personnel Board is very well versed in this subject area. Oftentimes we've pursued complaints for constructive medical suspension or termination in these scenarios, because what the agency is basically doing is disregarding the binding determination by CalPERS, and if the agency doesn't like CalPERS' decision, the agency has a right to appeal it. just as the employee does. But if they're not going to appeal it, they cannot deprive the employee of the right to return. And by not returning the employee, they are basically constructively medically terminating them. So we file complaints before the State Personnel Board to get the employee reinstated back to their position, and also to be made whole by being awarded back pay for the period that they were wrongfully denied their right to return, as well as any pay or any benefits that would have accompanied that return.
Can an employer require a psychological exam or a background as a condition of the employee's return?
No, they cannot, in our opinion. The term's mandatory reinstatement rights, it's supposed to be mandatory. That means the employee has to be given their position back. And most of the case law in this area has indicated that the employee really hasn't been separated from state service during a period in which a disability application is pending for review by CalPERS. They're still an employee. You're just waiting for CalPERS to make a decision on the employee's future. But if CalPERS makes the determination that the employee is not disabled, the employee resumes their employment as though no break in service had occurred. And if there was no break in service, there wouldn't be an ability on the employer to condition a return on psychological exam, background check. So the employer has to put the employee back to work. Now, if there's some reason to suggest that there's a psychological issue that the employer wants to have assessed, if they have some articulable basis, easy to say, for the employee to be evaluated, they have a right to do that. If there is something to cause concern that there should be a limited background post-return done, those areas may be explored by the employer, but the employee has to be returned before that happens.
Seems like you have to do this right because your financial future is at stake. And that's probably where you come in with a lot of guidance.
Yeah, I mean, I did a lot of this type of work at the law firm that I worked for before coming to CSLEA. I did a lot of disability retirement work, both administratively and in superior court and appellate courts. And it is very, very confusing, complicated area, both getting through the application process, getting back to work if your application's denied. And so it does take the guidance of a competent attorney. We don't offer formal representation on the application process. We have good referrals to attorneys that do that type of work. They're very expensive cases to litigate in terms of attorney's time. Medical experts to testify run in the thousands of dollars if you have to go to an administrative hearing. But if an employee is being refused the right to return to work, we represent employees under that circumstance. We also represent employees, and we have a case out of the Southern office in Southern California where an employee's been terminated against their will in the medical context. So if the employer's forcing an employee to go through the application process and the employee doesn't want to give up their job, the employee believes that they're still capable of doing their job, we will defend them in that process because the employer it's tantamount to firing them. They're trying to take the employee's livelihood away from them. So CSLEA will provide representation under those circumstances.
So Kasey, as we wrap up, is there any other advice or information you want to pass along to our members about this subject?
Yeah, sure. I mean, I would encourage anybody that has questions in this area. I mean, even if it's not something that we're going to necessarily provide formal representation, if they have questions about the application process, how it works, what their specific scenario is, and what the potential pitfalls are, I would encourage them to contact us either here in the Northern California office or in Southern California. And I'll close with just one other word for the wise is we at CSLEA also represent the CalPERS investigators who investigate people who file claims for disability retirement benefits. In the course of those investigations, they conduct sub rosa video to confirm that what the employee who files an application has represented as to their limitations is consistent with what they're doing in their day-to-day activities. So I would encourage people to give serious thought to filing an application only if you are clearly somebody who may be entitled to benefits, because if you're not, there are significant criminal as well as civil penalties, and I would hate to have our well-trained investigators out there finding some bad stuff on people who are also members.
And they are out there and they are finding some bad stuff.
That's true.
All right, and we want our members to know you're user-friendly, you have a phone at your desk, and all of our attorneys take calls from our members.
Correct. We take them all day, every day.
All right, thank you.
Thanks.